Good evening, ladies and gentlemen. I would like to call this special meeting of the Quorum Court to order and welcome everyone in attendance. The purpose of this meeting is to discuss the Washington County Dangerous Animal Ordinance, and the prayer and the pledge will be handled by J.P. Butch Pond. J.P. Pond.
We thank you, Heavenly Father, for providing us with the opportunity to serve the people of Washington County. We pray that our conduct here, our word and deed, would be pleasing to you as we should mind you in your holy word as we conduct ourselves. All this in the name of Jesus.
Amen.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Thank you, J.P. Pond. Carly, would you call the roll, please?
Daniel Balls. Here. Harvey Bowman. Rick Cochran.
Here.
Robert Dennis.
Here.
Lisa Ecke. Here. Ann Harbison. Here. Sharon Lloyd. Here. Tom Lundstrom. Eva Madison. Here. Sue Madison. Joe Maxwell.
Here.
Gary McHenry.
Here.
Joe Patterson. Butch Pond.
Here.
Bill Ussery.
Here.
We do have a quorum present. Thank you. Next thing we have is the adoption of the agenda.
Judge?
Yes, you're recognized.
I would move that we move the citizen comment move item 6 ahead of item 5 to allow the citizens to
I have a motion and a second to move the comments before the hearing. So let's just do all in favor, say aye. Aye. Opposed, same sign. Thank you, J.P. Cochran.
Second.
I have a motion and a second to adopt the agenda. All in favor, say aye. Aye. Opposed, same sign. Thank you. What we're going to do, Zegger, would you please explain the procedure for public comment?
Judge, this is not scheduled tonight for a public hearing. So what we have is simply regular public comment period. So this is a 15-minute comment period. It's open. There's no for and against. The standard 3-minute limit per person applies now. And then at the end, assuming the court moves an ordinance up to be considered before voting, there'll be another public comment period before that ordinance is voted on.
Do we all understand this? Okay, thank you. So we don't need for and against. We can just recognize as is.
Yes, Your Honor. Yes, Judge.
Raise your hand and come to the podium. Mr. Everett.
Ladies and gentlemen, my name is John Everett, and I live in Viney Grove, Arkansas. That's north of Prairie Grove, about 3 miles or so. It's in the country. I am here to oppose this ordinance. I want to say initially that I suspect this is prompted by the tragic occurrence back on 265 to a bicycle rider by a dog here a month or so ago. One of the interesting things to me about the ordinance is it does not solve that problem. It does not solve the problem of somebody having a dangerous animal that's just loose and takes the first bite. There's a free bite in it. You're not solving the problem that brings us here. I suspect this is prompted in large part by the bicycle riders, and we have a bunch of those in Viney Grove. They come by my house in groups and coveys of somewhere between 5 and 50 to 60 at a time. The part of the ordinance I want to focus on is the part that describes potentially dangerous dogs. If I had a dangerous dog, I'd make sure I didn't have him anymore, no matter the ordinance, as would every other straight-thinking and commonsensical person. But the potentially dangerous dog is so loosely defined and the consequences are so draconian that it virtually takes us out of the dog business in the country. Here's why. It says if a dog approaches or chases somebody, and there's some language in there about it being a menacing or with an attitude, an attack attitude. One of the interesting parts of the ordinance, and kind of funny to me, is how you figure out whether a dog got an attack attitude or not. I didn't get a chance to talk to my dogs about that, but I'm going to one of these days. But if he's menacing or has an attack attitude and he chases you or approaches you, then up jumps the devil. He's a potentially dangerous animal. Well, what happens, in fact, is that the bicycle riders come by, they all got helmets on, they're dressed up in spandex, which has these spectacularly bright colors on it, and it's a little hard-pressed to believe that the dog would not approach or chase that person. After all, from the dog's perspective, if you could imagine this, and I guess you could if you got to figure out what his attitude is to start with, but from the dog's perspective, they don't look like any people that they're used to. They look like aliens or terrorists or something. From the dog's perspective, of course the dog would approach them. Any dog would. But once that happens, then he's a potentially dangerous animal. The owner's got to hem him up. He's got to be microchipped, and whatever else happens to him, and the policeman can put him in the dog jail over there for a while if he wants to. The other problem with the ordinance, it seems to me, is that the law enforcement officer can take a written complaint by one of the bicycle riders and magically label the dog to be a potentially dangerous animal. Our experience with the bicycle riders in Viney Grove, and I know a bunch of them, and I like them, and they're good people, but some of them torment the dog. We got a guy that comes by the house all the time, and he'll ride by and say, bark, 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 to the dog. You ought to adopt an ordinance about him and about the bicycle riders in general. But it's not the dog's fault that he gets a little anxious about all that, doesn't seem to me, nor is it the owner of the dog's fault. However, recently, by the way, I saw another draft of this ordinance that talks about hazardous dogs, and all of them are hazardous if you apply that, for after all...
Mr. Everett, your 3 minutes is up. I'm terribly sorry, but thank you so much for your comments.
Thank you.
Who's next?
More I wanted to say.
Thank you. Who's next?
Can John have my 3 minutes?
No. Come forward, Cheryl, and identify yourself.
Yes, my name is Cheryl West, and I live in Viney Grove as well. And John's pretty much covered everything that I had to say. I am curious as to who will police this. It will be the bike riders that call the appropriate authorities, and then they will go out. Is that how this would be handled?
Can you answer that, Steve?
Well, it will be complaint-driven. So the idea is that, and we actually talked about some of this before, but yesterday and before, a reporting system from somebody who's willing to say in court that dog did X, Y, or Z and be able to point.
Okay. I would just ask that you take into consideration that our lives in the country have been changed by the many bikers that we have. As Mr. Everett said, on any given day, we have numerous bikers in our community, and at times it can be very dangerous. My husband and I move a lot of farm equipment across the roads, and there's many times that they're there and they won't move for us. And we just ask that they respect us, because we are respecting them and allowing, and we know they want to come and enjoy our country. It's beautiful out there, but we just ask that they be respectful of our thoughts as well. Thank you.
Thank you very much.
Tell them we just got a petition opposing this delivered, and there it is, but you got that.
Yes. He just handed me a petition of many signatures of people opposing this ordinance. You want me to leave it here?
Would you please give that to Karen, Cheryl, or Carly? Thank you very much. Anyone else like to speak? Yes, ma'am, come forward and give us your name, please.
I'm Verna Harden, and I live down by Devil's Den, so you can only imagine the bikers I have down my way. I'm a dog owner. We've lived down there over 30 years. I've never complained or anything else about a neighbor's dog. We've usually just had to deal with whatever we needed to do. Most people are, they're good dog owners. If you have a vicious dog, you don't keep it. I wouldn't have one around my farm. Under the same token, you have bikers and whatnot turn up. And, a dog doesn't know a road, this is my line, this is where I'm going to go. You have somebody ride by, and they're going to bark. And that's what dogs do. That's what I want my dog to do. I don't live right on the road. My kids live on the road. My dogs are my first line of protection. If I called 911, it'd be at least 30 minutes before the police got there. And it's not a fault of the police, it's my location where I live. That's where I live because I choose to live out there. My dogs, if Somebody drives up, I was at the barn the other day, my dogs went to barking. I knew somebody was on my property. That's why I have my dogs. You know, I don't agree with potentially dangerous. Shoot, a marshmallow is potentially dangerous to a diabetic. Anything can be potentially dangerous. There's just so many things in here. If you could see it, I've went through and underlined and marked out and read and thought about it. Like I said, you've got to have the wisdom of Solomon. I know something needs to be changed, but I don't agree. They come out to our area in the country. They've got miles and miles of bike trails, and I'm like Mr. Everett, they harass the dogs. You know, it's not the dog's fault. The dog can't speak. So that's why I came, just to support the animals and the people that do live on the roads and deal with it. Because you would not believe, I don't know how many people they needed to come and talk for themselves because they have problems with the runners and the bikers. I mean, they're good people. I agree. And I understand why they want to be out there. I love my area, but there's got to be a kind of happy medium.
Thank you, ma'am.
Thank you.
I saw someone in the back. Come forward and identify yourself.
My name is Paxton Roberts. I live here in Fayetteville. I'm also the executive director of the Bicycle Coalition of the Ozarks, so I get to speak for a lot of the cyclists in the area. I respect definitely the comments I've heard previously from the audience. I think it's definitely a symbiotic relationship that needs to be had between people enjoying the countryside, whether it's walkers, runners, or cyclists. I'd like to stress that this isn't just a cyclist issue. Walkers and bikers walk out on the country roads, both paved and dirt roads. I myself grew up in the country, so I know that we used to walk the roads, and we have had issues with dogs. I have dogs myself, so I'm very much wanting something to come in place that protects dogs and protects the owners and protects the people that are using the road. I know not everybody may agree that cyclists may ride on the roads, but it is the state law. And it's becoming a very big pastime in our region. This area is becoming known as an international cycling destination. We have people moving here because we have the wonderful scenery, the wonderful trails, the wonderful roads. So I would just like to voice my support for the ordinance. I agree that we need to make it and have as much protections for the people using the road as for the dog owners and the dogs themselves. I know I've seen dogs killed from hitting bicycles, from bicycles running over them. No cyclist likes to have a dog and be the one that killed a dog for running over it. And I've also know people that have had their lives permanently changed. There are dozens of people that I know personally that have had accidents from a dog running out and not even biting them, but causing the accident by getting in front of the wheel or lunging at them in a way that they maneuvered and get out of the way. And so I think somehow we have to figure out an issue to stop having people go to the hospital just for riding their bicycle or just for running or walking in a public area. And so, but like I said, I definitely appreciate the comments I heard from the dog owners. I grew up out in the country, so I can relate to them a lot. And I just appreciate the time that this court has put into addressing this issue, because I know everybody up here has spent a lot of time. So thank you.
Thank you, sir. Anyone else? I want to thank all of you for your time, and thank you for being here. Yes, J.P. Dennis?
Thank you, Madam Chairman. I'd like to move that we suspend the rules and let Mr. Everett finish his conversation.
Second. I have a motion and a second.
It's not debatable, Judge, but it'll take 2/3 to pass.
Okay. Carly, would you call the roll, please?
Tom Lundstrom. Eva Madison.
Yes.
Sue Madison.
Yes.
Joe Maxwell.
Yes.
Gary McHenry.
Yes.
Joe Patterson. Butch Pond.
Yes.
Bill Ussery.
Yes.
Daniel Balls.
Yes.
Harvey Bowman. Rick Cochran.
Yes.
Robert Dennis.
Yes.
Lisa Ecke.
Yes.
Ann Harbison.
Yes.
Sharon Lloyd.
Yes.
Welcome, Judge.
Mr. Everett, you're recognized.
Well, thank you. This won't take very long. Most of what I was going to say afterwards was this. If you're just hell-bent on passing an ordinance, if you are, I hope you're not, but if you are, there should be some dramatic changes to this one. For example, the ordinance you have offered up and drafted says that if I got a dog that's been labeled as a potentially dangerous dog, it's a misdemeanor. It's a misdemeanor if I don't follow your rules. What about the old boy that makes and it says that if a complaint is made and is substantiated, the dog owner has to pay for the investigation. Well, if you're going to create an entirely level playing field, why don't you make it say that if the complaint is lodged and it is not substantiated, then the complainant has to pay for the investigation. After all, it would create some economic incentive for the complainant not to just do it as a harassing technique, for after all, the way the ordinance is written now, it's so one-sided. And if it's going to be a misdemeanor for me not to follow the rules, why is it not a misdemeanor for them to make a complaint that's not substantiated? If you're going to adopt an ordinance at all, it makes no sense to make it so one-sided that the bicycle rider, not to say that they operate with a black heart, because most of them don't. Some of them, I think, do, as a matter of fact, but some of them don't. To say that they can lodge a complaint and require me, the dog owner, to jump through the hoops, and if it's substantiated, I get to write a big check and have my dog castrated and put in a dog jailhouse for 3 or 4 days and microchipped, and then I got to go to dog obedience school or whatever they call that thing, all that I have to pay for, and they don't have to do anything except write a note to Sheriff Helder saying, hey, John Everett's got a dog out there, and he approached me, and I thought it was in a menacing manner. Love, Fred. That makes no sense to me. I don't think it's fair. I don't think you intended to do that. One of the other parts of the ordinance that I think has an ambiguity in it that you've got to fix is this. When you're describing what kind of describing the animal, you talk about a dog that approaches somebody on a public way or public property or a public street or something like that, and you cannot, by looking at the ordinance, figure out if that means the bike rider's on the public street or the dog's on the public street, or both of them has to be on the public street. I think your intent is to say, well, if the dog's on private property, then it's okay. He can bark, he can chase, he can approach. If the guy's on public property and he keep himself on public property, then no harm, no foul. But that's not what your ordinance says. It can be read to say that if the bike rider's on the public street, the dog's in the yard, then the dog can be a potentially dangerous animal even though the dog stays in the yard. And one of the curious, and this is entirely a side note, curious parts to me is the people like to ride at Viney Grove, and one of these ladies gave a very good reason why that's so. But you know, the taxpayers have built $16 million worth of bikes, trails. Somebody gave me that number, it may be wrong. You can ride a bike from here to Missouri and stay on the designated roads for bikes. There's bike trails on the highways, it says, bike trails. You know, they can ride those bicycles out there. Now, maybe that's too big a price to pay, I don't know, but the bike riders are becoming an enormous nuisance to those of us who live in the county, and we have to hold up our farm equipment and hold up our pickup trucks and our cars, and we can't go to the grocery store because we have 50 bike riders, none of which will get out of the way. And it seems to me like you're trying to drive a thumbtack with a sledgehammer to approach it in this fashion, and I think the ordinance is nonsense and should be defeated. Nonsense may be too strong a word. Sorry I used it. Thank you very much for letting me speak.
Thank you, Mr. Everett. Okay, I think we have heard from our public, then we will proceed with our ordinance at hand. And again, I want to thank each and every one of you for taking your time to come this evening. The next thing we have is the ordinance.
Justice Sue Madison must be ready.
Yes, I'm sorry, J.P. Madison.
Thank you, Madam Judge. I want to understand exactly where we are. The ordinance that we considered last time is still on first reading. Is that correct?
It's still on first reading, that's correct.
At that time, it was considered as an emergency ordinance,
Yeah, that's right.
and it could have passed that night on the first reading.
With with an emergency, that's correct, yeah.
You
What-
did.
Does that nullify the emergency aspect of it in that we didn't do that night?
No, the ordinance still has an emergency clause on it. So if it passes by 10 of the 12 of you present tonight, because it's 2/3 of the court, then the emergency clause would still go into effect. It was actually tabled at the last meeting, so it's coming back on first reading tonight.
Right, we didn't. Okay, so we could pass it with one vote that would require 10 votes.
That's right.
Thank you, Judge.
Thank you. J.P. Harbison?
think Mr. Everett is correct in that this ordinance does not really tell us that the bikers are on public property. As long as those dogs are on their private property, there is no problem. That is not really clear in this ordinance. So therefore, I'm going to make a motion that we go on and table this again so we can get it right. Because I think this is very important that we get this ordinance right. We need to protect the bikers, but we also need to protect the dog owners. It's just a culture in the country, and I've lived in the country all of my life, that you have a dog. But I think people realize that their dogs cannot be out in the road chasing bikers. But I think, if they're in a yard and they're barking at bikers as they go by, I don't think that's a problem. We have a problem, and the lady, Mrs. Harden, said, we've got to have the wisdom of Solomon to solve this problem. So
the motion is not debatable, so I think that if there's not a second, we're going to continue, but if there's a motion to table on the floor, it's not debatable.
Second. That's correct.
I'm going to recognize Zaga here.
we got a
Yes.
second.
Okay.
Not debating, simply clarifying. If it is the court's will to send this back for more work, might I suggest that the correct motion would be to recommit it, in other words, to send it back to services, as opposed to simply tabling it for the whole court, so that you're not meeting in full session again. That's simply a suggestion.
May I restate my motion then, that
Yes,
it be
please
sent
do.
back to committee and reworked?
So, okay, you're recognized, Jackie Madison.
This is the third time we've been together to discuss this. This is not new law. This was law that our county attorney provided us from a state that's had this law in the books since 1987. I didn't create the language that we're talking about. We've all refined it. I think the people that have been most affected by this are disappointed that this court keeps passing the buck on this. We just keep delaying. If it's not perfect, then why didn't people come tonight with fixes? J.P. Ussery came with something he thought would improve it. We didn't get a ton of notice, but at least he did the work to get it to us. I don't think we can keep passing the ball on this. If it's not acceptable, vote it down and someone else draft one that does the problem. But for us to have met on this now for a third time and to keep passing the buck, it's going to come back to the committee that already passed it out. I don't think that makes sense. I think this court is not being courageous to deal with the issue at hand. The laws that have been criticized have been laws that were provided to us by the county attorney from another state, like I said, that's been around for decades. I think we're not being courageous in facing this issue. And you think about how many people we've heard from, repeated email after email after email after email that have been in support of this ordinance. In addition, no other ordinance since I've been on this court has been subjected to a public hearing. We subjected this to a public hearing and added additional notices in the paper. And no one came and spoke against the ordinance as a result of that. Tonight is the first time we've heard any opposition to this. No. In the court we have.
I'm sorry.
So I just think that.
I think the motion to recommit is also not debatable, frankly.
Right. Point of order.
Well, I was recognized, so.
Just saying.
Okay.
So we're not debating?
I call the question that we vote.
Well, okay. A motion to recommit is not debatable. It's an incidental motion, not debatable. So Judge, I think what's in order is to vote on Justice Harbison's motion. It requires a majority.
I had a motion, and who was the second? Rick, okay. Carly, call the roll.
Tom Lundstrom, Eva Madison,
No.
Sue Madison, Joe Maxwell,
Yes.
Gary McHenry,
No.
Joe Patterson, Butch Pond,
Yes.
Bill Ussery,
No.
Daniel Balls,
No.
Harvey Bowman, Rick Cochran,
Yes.
Robert Dennis,
No, I want to work on it tonight.
Lisa Eki,
Yes.
Ann Harbison,
Yes.
Sharon Lloyd,
I don't think I matter.
Yes.
By a vote of 6 to 6, the motion fails.
So we are ready to move on for discussion. Is this correct?
Judge, traditionally at this point, you would recognize one of the two sponsors.
Okay. You recognize.
Thank you, Judge. Since we've already read this once, Mr. Zago, we don't need to read it again,
You
correct?
need to, well, we're back on first reading. You need to suspend the rules, and it depends on which one. I have to at least read it by title only tonight.
Okay. Then I move that we suspend the rules and read by title only.
Second.
I have a motion to suspend the rules. I have a second. All in favor, say aye.
Aye.
Let's do a roll call.
May I ask a question? Are we voting on the original ordinance, not what's been added by Bill Usry?
Yes, we are.
This is the original ordinance?
Yes, ma'am. Okay, let's do a roll call. That was kind of weak.
And it's simply to let me read it by title only, not, you're not voting on passage now.
Carly?
Tom Lundstrom, Eva Madison,
Yes.
Sue Madison, Joe Maxwell,
Yes.
Gary McHenry,
Yes.
Joe Patterson, Butch Pond,
Yes.
Bill Ussery,
Yes.
Daniel Balls,
Yes.
Harvey Bowman, Rick Cochran,
Yes.
Robert Dennis,
Yes.
Lisa Eki,
Yes.
Ann Harbison,
No.
Sharon Lloyd,
Yes.
Mr. Zager, would you read it by title only, please?
An emergency ordinance amending Washington County Code, Chapter 2.7 in regard to dangerous and potentially dangerous animals.
Judge, should I still have the floor?
Yes, please.
At this point, I move to pass 5.1.
Second.
I have a motion and a second. Okay, we got discussion. Let's recognize Mr. Maxwell.
Thank you, Madam Chairman. Couple of questions. One, I do have a question about when we talk about the animal owner's property. I know in my case, I own to the center line of the highway. It's easement granted to the highway and they maintain all that. My question is at what point does it become not the property owner's property and become public property for the county roads and the state highways that we're discussing?
The public has a right to traverse ingress, egress, that's ingress and egress. The public has a right to come and go on that highway as a public right-of-way. So while, yes, you own it in theory, it's essentially a permanent easement granted to whichever governing body owns the road, essentially.
However, the way the ordinance is stated, it's stated as the animal owner's property. So would that be in contention if someone has something happening? I own both a county road completely and I own up to the center line for the state highway in front of me. So I can just see where this is going to be cumbersome to interpret if we're not clear at the start.
I can tell you that Mr. Everett would certainly, if he were defending it in court, say that. And criminal statutes are strictly construed in favor of the accused. So if we are not, that could be clearer to make it. I think that a prosecutor could win the argument, but I think you are giving the prosecutor an argument to win, potentially.
Okay. I would like to offer an amendment. I've had this, something that I recognize, and I think Mr. Everett has recognized as well, that it is, for the budget side of this, on section 2.732, under cost, we have for a substantiated claim becomes the responsible cost of the investigation goes to the.
Page number?
Page 10. It's the same. Page 10. Yeah, let me look at let me find it in the original version since we're,
I think it's page 9. 2.731.
no, page 10, 2.731. Mine says page 10, I'm sorry. Mr. Zagat.
2.732.
You're on the new one, honey.
Yeah. The one that says P9, P10 in the bottom right-hand corner.
Folks, you are looking at the original ordinance. You're not looking at the amended one that.
It does say page 9 at the top left, so that's somewhat confusing. So the amendment that I would offer would be to give fair balance to both of that so that there's not a financial burden on the county in the event of unsubstantiated claims. So we have the verbiage there. It says if a law enforcement health official is required or requested to investigate a violation of this article and the complaint is substantiated, then the reasonable cost of the investigation shall be assessed against the animal owner by the court. So my amendment would start there and would simply state the same verbiage. If the complaint is unsubstantiated, then the reasonable cost of the investigation shall be assessed against the complainant by the court.
Second.
Yes, please.
Mr. Zaga, this is existing ordinance. This is not part of what we're proposing to change, and so I'm a little confused about why this is an issue, number one. But then I'm also, I don't know how you do that.
Justice Masson, you're correct in that this is Washington County, Arkansas law, like 2731 is Washington County law now. And what was the second half of your?
How do you shift it? I mean, if the sheriff's office says, I mean, they might find something as unsubstantiated, not because they think the complainant was a liar, but because they just don't think has enough proof to go to court. And what I'm hearing is that we would then shift that cost to the complainant who may have been acting in good faith. How do we do that?
Well, it would certainly be unusual in Western jurisprudence, I guess, to put, unless you found, and that brings up another point, I guess. There is a misdemeanor on the books in Arkansas called filing a false police report.
Right.
So if somebody acted in malice and bad faith and, the officer believed that, the officer can file a charge of filing a false police report, and if the prosecutor feels that it's necessary to do that, and as part of that statute, if I'm not mistaken, it's been a while since I looked at it, that statute already says reasonable cost of the investigation can be assessed against somebody who files with malice or knowingly falsely, essentially.
Because my concern is, I know, just from my law practice, that people make complaints in good faith and then they don't go anywhere because law enforcement just finds that there's not ample facts or witnesses or whatever. And I would hate to think that now we punish those people by saying that they have to pay for it. That didn't seem right. I would rather trust law enforcement to find out if someone filed a false report and punish them appropriately. I mean, like I said, this is not part of the ordinance. This is existing. So if we have a problem with this, I think we should strike it completely, not try to shift the cost the other way, because I think you're punishing people acting in good faith. So I can't support this amendment. Thank you, Madam Judge.
Yes, J.P. Madison.
Thank you, Madam Judge. I guess I'm concerned about the language that said if it's unsubstantiated by a court. I would think a lot of these kinds of complaints will be handled by our law enforcement or animal control. And if you can't determine who the proper owner of the animal is, that might result in it being unsubstantiated because you don't know who, he says it's Uncle Joe's dog and she says it's nobody's dog. I'm concerned about changing it to this degree that might take a lot of incentive for establishing that first problem that a dog has. If you take away that option when that dog is first threatening, then its next bite or its next attack may be that much more vicious because we weren't able to label it in the beginning as being potentially dangerous. So I'm very concerned that this, in a lot of ways, takes a lot of the preventive out of this ordinance. Thank you.
JP Essery.
I'd like to offer that we go with 5.2 instead of 5.1. And I'd like to give a brief explanation, if I may, Judge, of what precipitated this.
Okay, we've got, what is our motion on the floor?
5.1's on the floor, Judge, so sorry. With respect to Justice Ussery, 5.2 is not in order for debate at this point in time.
Okay. At the proper time, I'd like to do that. But if I may I go ahead and explain why I did this? Or is this the
You're
time to do
recognized.
that?
Go ahead.
We're on JP Maxwell's amendment, I think, right now.
Okay, I'm
Sorry,
sorry.
I'm not-
Hold up just
No,
a minute.
No, we'll finish with his amendment.
Okay. You made the amendment. Who seconded that? Was it? I seconded. Oh, okay, I'm sorry. I didn't see. Any other discussion? Yes, JP Dennis.
I'll state it out front so you'll understand. I'm for having a dog ordinance, I really am. And I'll use my grandson as the example. My grandson has to get off the school bus and walk, and he has to walk by a boxer and a pit bull. They tie him up, but now they've started turning them loose. And I asked Rhett, I said, and my Viney Grove folks will understand, he lived out there for a while, and he loves animals. And he has been bit by a neighbor's dog. But I asked him, I said, what are you going to do if those dogs are loose and you get off the bus? Because he can't outrun them. No trees to climb. He said, I pick up the biggest rock that I can find and I carry it until I'm past those dogs. And now he just doesn't even go that way. He comes to our house and stays there until he gets a ride home. So, and then the other thing I wanted to say was my other neighbor right behind us she's a good dog person. She has one that's rather intimidating looking. And one of our other neighbors called the sheriff, complained that the dog had knocked her down and hurt her and wanted something done about it. And so the sheriff or the deputy got them together, it might have even been a Farmington police person, got them together and brought the dog, or Ashley brought the dog out. And the lady just said, oh my gosh, I am so sorry. That is not the dog that attacked me. But yet she was so sure when she made the claim, she didn't have any intent. I mean, she was just sure she knew. It was just a common looking dog. But this particular dog has its eye out. And so it was very, very distinguishable to the lady. And she said, that is not the dog. I'm so sorry. Now, she was sorry for making the charge and the claim. But at the same time, if we leave it too loose on what we're saying, who would have paid for the investigation? The owner of the dog would have. And yet it wasn't her dog that did it. And so I think I don't know how you do it. I'm not the legal authority, and I'm not the one to write a law, but at the same time, common sense says we need something to protect both ways. And I do understand that. Mistakes are made. And emotions run higher on dogs than they do on any other thing. And I've seen more fights started over dogs than kids. And so I do want us to write it carefully. I'm for having an ordinance, and I'm really tired of that pit bull dog threatening my grandchild. It doesn't have anything to do with a bicycle. If he's on a bicycle, he could outrun him. So it's not just a cyclist thing. And, we're trying to write a law that encompasses the whole county. And I'll just tell you, my grandson needs some protection. And if I go knock on that person's door right now, there's no law that says they've got to put him up. They're running free now. And so he doesn't go home. And I just hate to think that another kid that gets off that school bus and walks in that same road might get attacked. So I'm for an ordinance, and I'm for responsibility, and I'm for responsibility 24/7 of animals that can be vicious. If a person doesn't have a single worry at all, and that's what I've told several that have called me, they say, my dog would never attack anybody. Well, I said, well, this is complaint-driven. And if it's complaint-driven, then you have nothing to worry about because no one's going to make a complaint on your dog. End of story. But if your dog does, then we have a law that's on the books and something can be done about it. So I'm in favor of a law. I just want it written correctly. Thank you.
J.P. Cochran.
Judge, there is a motion on the floor, and I was going to make a motion, so I'll get back in line after
Okay.
we make a vote. Thank you.
Justice.
Yes, J.P. Pond.
Yes, I've already one time had the opportunity to compliment Eva's work on this ordinance. I think she's done some very good work on this ordinance. I just, because of some public comment made this evening, it's brought to light, as far as I'm concerned, it does need some more work and some more thought. And the landowners and the dog owners and the people who live in the county need protecting just as well.
Okay, point of order. What is your?
All right.
Thank you, Judge. There is a motion on the floor, and discussion should be on that motion.
That's correct, Your Honor, Judge. If Justice Pond is coming to Justice Maxwell's amendment,
We're still on Justice Maxwell's
you haven't voted
amendment,
on it yet.
which I don't have a problem with Justice Maxwell's amendment. I just want to make sure that it covers the concerns of the people that made comment this evening. Could we get public comment on the amendment?
Not unless you suspend the rules.
I move we suspend the rules and hear from the public on Justice Maxwell's amendment.
Second.
I have a motion and a second.
It's not debatable, Judge. So.
Okay. Does anyone in the public want to comment on this?
We need a vote.
Okay, I'm sorry. So, Carly, call the roll, please.
Tom Lundstrom. Eva Madison.
No.
Sue Madison.
No.
Joe Maxwell.
Yes.
Gary McHenry.
Yes.
Joe Patterson. Butch Pond.
Yes.
Bill Ussery.
No.
Daniel Balls.
No.
Harvey Bowman. Rick Cochran.
Yes.
Robert Dennis.
Yes.
Lisa Ecke.
Yes.
Ann Harbison.
Yes.
Sharon Lloyd.
Yes.
So we've got public comment now.
Then this is a two-thirds of you here. This is not on the ordinance. So I have 8 in favor and 4 opposed. The motion passes.
Judge, may I ask a question before we?
Yes, go right ahead.
I need some clarification here. Justice Madison brought up that this is a Washington County, Arkansas law, and it cannot be changed.
No.
It can be changed. Just not what?
The point, may I?
Yes, please.
Justice Eva Madison made, I think the point Justice Eva Madison was making was that 2731 is currently on the books, except for a couple of editorial changes that you see in front of you. That's on the books. You can change it, and this ordinance would change it, in fact, with those editorial changes. Justice Maxwell's amendment would be a change.
Okay, thank you. The other clarification I need is when we see, for example, on exemptions on page 10, section 2733, B, all of that is stricken, going down to pursuant to Arkansas Code, and it goes on and on and on. Is all of that was stricken no longer in the ordinance?
If
or
you
is
pass,
it-
if you pass this, the struck-through language would be deleted, the underline,
Who struck through, I mean, it was that was in committee. That's not what's on,
well, between Justice Madison and myself, Ms. Beeks, that's how that came to be struck through, and that's to let you know which language you're removing, and the underlying language would be the language you're voting to essentially substitute for it,
okay,
or add to that subsection.
okay. Thank you for the clarification.
J.P. Harbison,
Could we have the exact wording of
the amendment.
J.P. Maxwell's amendment?
You have that written down, JP, but would you please
I do.
read that for us?
If the complaint is unsubstantiated, then the reasonable cost of the investigation shall be assessed against the complainant by the court. It's exactly the complementary wording, exactly like the substantiated claimant would assess that charge against the dog owner or the animal owner. So I just took that exact verbiage and
Okay.
reciprocated. Thank you.
You understand that, JP Harbison?
Yes.
Okay. Are we ready for a vote on this?
No, your public comment.
Okay. So anyone want to comment on this amendment that JP Maxwell has proposed?
Well,
Come forward.
Judge Everett, I'd like to just make a brief point.
Okay, go right ahead.
And it goes to the idea that filing a false police report is an answer to this problem. It's not. And there's a lot of reasons why it's not, but in order to be guilty of filing a false police report, you've got to show, lawyers call it a mens rea, a black heart, a criminal intent. But that's not what this ordinance you've said you've drafted up says. It just says whether it's substantiated or not. And I just don't think it's fair to say, well, if it is substantiated, the dog owner pays. If it's not substantiated, the public pays. I think there should be some economic disincentive to the bicycle rider or the walker or the neighbor who doesn't like me or doesn't like my dog and wants to get the police to come look at me. That doesn't make any sense to me. It seems like there should be some equity in it. And I think that amendment addresses at least that problem. There's a variety of other problems with the ordinance I've already talked about. Thank you.
Thank you. Any other comments?
Paxton Roberts, Fayetteville. Just wanted to ask, I guess, a clarification. I believe I heard that there was already a procedure for dealing with an substantiated claim, that if a police officer showed up after, say, let's just say a runner instead of a cyclist for a change, a runner called and was standing there, and if it was a false claim, there was no evidence that anything happened, that the police officer, I mean, that's filing a false claim? Is that
May I?
already covered? I mean, I
No,
just heard that mentioned. I was
no,
asking
there-
for some clarification.
I want to be, didn't come here to litigate against Everett, although I appreciate the opportunity to do that. He's right, okay, in that filing a false report means you have to know that you have to tell a lie. It's not saying that's the dog and you in good faith believe it's the dog and the officer determines through investigation, no, that's not right. For whatever reason, doesn't file the report. That's not filing a false police report. Filing a false police report is saying that dog attacked me knowing in fact that it did not. And I'm generalizing quite a bit. So filing a false report requires somebody essentially to lie to the police.
Okay. And so I felt like that's what the concern was from the comments previously, that somebody would make up a lie, a neighbor or a cyclist, just to say the dog comes out, and then if that was the case, they would have to pay for it. But if a dog chased a person and they didn't have any physical evidence, a recording or a video or anything that the dog chased them, called the police and came out, if the police officer has to determine who's telling the truth, I guess, and if is that when the cost would then be incurred? Or I heard the word court, so it's only if it goes to court? Is that?
That's the way the amendment reads now, but I think that's also the way 2731 reads now on a substantiated report.
Yeah. So my concern would just be that this would, I agree, you want to protect the public from false claims or somebody making something up. But that if, somebody was a financial burden was placed on after you had been chased or attacked and you just didn't have any money and that prohibited you from calling, I could see that being a potential issue. I understand it's both sides, but, some people would be scared to then file a complaint, even in a legitimate aspect of it, if they didn't have a video or didn't have a photo, and that's going to be a case in some of these. So that would be my concern about the flip side of this. I understand the need to protect the public from it, but So, all right.
Thank you, sir. Anyone else? Okay, we're going to go back to, we've got a motion.
I don't know if there's further discussion on the court, Judge, but Justice Maxwell's motion to amend is what's before the court now.
And we have a second by Henry. Yes, J.P. Acker.
Thank you, Madam Judge, and thank you for your patience. Justices also. When does the sheriff's department go out? I mean, if somebody says, a cyclist, a jogger, a walker, whoever says, this animal chased me, is that enough for the sheriff's office to go out and investigate? So just by saying it chased me, did anybody see it chase you? No. So when the caller calls in, I was just chased, it is immediately investigated. Or somebody said, yes. Yes. Okay. Thank you for that clarification. Thank you, Madam Judge.
Any other discussion? Yes, J.P. Madison.
Thank you, Madam Judge. I want to respond to the comment that was just made, that is, to me, what is going to be the undoing of this entire ordinance. If somebody is walking home from the school bus, if somebody is jogging and there's nobody else around and a dog chases them and they don't video it with their phone, they're probably not going to call it in because they're going to say, well, who's going to believe me? It's a black dog. And then we won't ever get to step 2 with that dog that was threatening that person. I think the whole point of having this potentially dangerous is to identify an animal before it goes on to do a truly vicious attack. And I'm concerned with J.B. Maxwell and I love his positions on many, many issues, so this has nothing to do with my high regard for him. But I think this proposal, while attempting to add an air of fairness, will take a lot of the potential good out of this ordinance, because there will be a reluctance and a fear if you don't have solid, concrete proof or a sheriff's officer standing there and witnessing it. So, thank you, Madam Judge.
Okay. J.P. Maxwell?
Thank you, Madam Judge. I guess my question, perhaps maybe for the sheriff or someone from that department, would be, in the event that there is a chase or a menace or whatever, there's no video, there's no witness, whatever, what would you do with a complaint like that, whether this was in here or not? It seems to me as if, with my precursory understanding of this, that then becomes very difficult to do anything additional with anyway. But I certainly am open to hearing if there's other recourse, if there's no witness, no documentation, or whatever, how the sheriff's department would approach that. Because if there's nothing to approach, then that may not make a difference for this ordinance, or for this amendment to the ordinance.
Are you asking someone from the sheriff's office to come forward?
Yes, please.
Okay. Dallas?
Dallas McClellan, Washington County Sheriff's Office. Under the ordinance, and as what's going on with the current ordinance, if someone calls and complained of a dog, say one has chased a runner or a bicyclist, we would go out, we would take a statement from the runner or bicyclist, we would talk to the dog owner, and as of now, we would make a determination if we would deem that dog vicious, is what we've done in the past.
Can you help me understand, how would you make a determination on that if there's no, kind of the situation Justice Madison brought to light, if there's no documentation, no witnesses, whatever, it's just kind of a he said, she said type of a situation, what do you do in that case?
The way we do it now, we would talk to the dog owner. The dog owner may tell us, look, I've never had a problem, or my dog's never bit anybody. We would know that from call history, how the dog acts towards us. Now, you know, Mr. Everett's right. Dogs act different when bikes go by than when people are standing around, because it's a different activity that they see. So, but we're also going to err on the side of caution. So if there's something that dog does when we get there, or there's something the owners may say, then we're using officer discretion if we're going to deem that dog vicious under the current ordinance.
So I guess then the follow-up question would be, what would you estimate the cost, I know that's difficult, what would you estimate then the cost of that investigation being, should it be unsubstantiated? What would that end up costing a complainant if they, I mean, is it exorbitant or is it something that would be pretty
Well,
negligent?
It'd be, our deputies got an hourly rate. I mean, there's a general cost of what it costs to operate a vehicle and a deputy per hour. I mean, if it came to the fact that we had to put a pen and pencil to it, I can't really tell you right now, but I mean, there would be some cost, but it'd be based off an hourly rate.
Okay. So we're really looking, I don't want to put words in your mouth, we're looking at $20, $25 maybe.
Yeah. I mean, that's, I really wasn't prepared to answer that, but it could be close to that.
Okay. Thank you, Madam
Anything
Judge.
else?
Piecki? Oh. Any other question for Dallas? Thank you. Okay, hang. Okay, go ahead.
To you, what is it, have you read this ordinance?
Yes, ma'am.
How is it different from what we have?
Well, from what we have is there's due process for the dog owner that hasn't been in the past. In the past, if we deemed a dog vicious, if the owner disagreed with it, they could contact the sheriff's office and deal with someone from staff. I've looked into them, or my lieutenants have looked into it, and made a determination off what the person presents to us. If it was just cause or probable cause to believe that dog is vicious. And in all my years' experience, I've only had one that I overturned, and it wasn't a dog that had actually attacked a human. It was a dog that attacked a cat. So in the past, it gives the dog owner due process if we do deem a dog vicious. But what it also does is, normally, if we had received a call and we went out and we deemed a dog vicious, and we put that person on notice, we don't issue them a citation, and we give them what's under the current ordinance that we're operating off of now, what they have to do to keep that dog penned up and to keep people safe.
I'm having a really hard time. I mean, we've got a lot of words here and a lot of sentences and a lot of terms, but when you come down, I like things short and simple.
So
and
do
I
we.
want to know the difference between this ordinance and what we've got. I mean, I really can't see that there's much difference.
Well, there's difference towards the dog owner of what the dog owner has to do if a dog, even if it doesn't bite somebody, if it's potentially damaged, what the dog owner has to, how the dog owner has to confine and keep that animal.
So you can't do that now.
What we do now is it's nothing or it's all. If a dog if we feel that a dog has been deemed vicious, and that's officer's discretion, then the dog is deemed vicious, and then we place it under the current ordinance.
Okay, so you're saying really the only difference is that the dog owner has a recourse of taking it to the county court or circuit court.
From what I believe, yes, there's due process for the dog owner. If he does not agree with the findings of us declaring that dog potentially dangerous or dangerous under the new ordinance, then they have a right to appeal to the county court, and it will go through an appeal process.
Okay, thank you.
Thank you, Dallas. Did you have something for Dallas? Yes. Go ahead.
And we're still on Justice Maxwell's
Yes.
amendment, which you completely understand Justice Maxwell's.
Yes.
Does this amendment we're discussing leave the same amount of room of discretion for the, let's say, you go out, the officer goes out and determines, well, this was a bogus call. Is there room for discretion here as far as this amendment goes? Could your officer go out and say, well, this caller was mistaken. We might not necessarily have to make this plaintiff pay up this time.
Absolutely. I
Okay,
mean,
all right, very good.
if we feel that, we have to, like any other criminal charge, we have to show that the person intended to commit a criminal act, which would be intended to mislead us in a direction that was, example would be, someone said that a dog tried to attack them, that this dog right here tried to attack them, but the homeowner has surveillance system outside their house, and it shows that the dog never left the porch.
So.
So that's something that we could prove that someone intentionally did something that they didn't do.
So, if somebody really was frightened of the dog, and you showed up and you found out, well, the kid was really scared, he called us, but, the dog just tried to lick him to death, you wouldn't necessarily have to, okay, that was my main concern.
We still have to deal with the human factor of
Okay.
everything.
Thank you.
Are you wanting to talk to Dallas?
I want to perhaps eliminate some of this difficulty by a little wording change.
Okay, I've got Ecke, I've got Madison, and then I've got Maxwell. So I'm going to take you in order. Ecke. Okay. Next thing I have is J.P. Madison.
Thank you, Judge. I am interested to hear what J.P. Maxwell has to say, because the situation that Captain McClellan has talked about with you all going out and deciding that you couldn't substantiate it, let's say that's J.P. Dennis's grandson, and he's staying there with his grandson. The way I understand the proposed ordinance is you're talking discretion in terms of pursuing them for a false police report. The proposed amendment does not allow discretion. We would have to give J.P. Dennis and his grandson a bill for the sheriff's services. I don't think the county should ever be in the business of charging citizens who file complaints about violating county ordinances. That is not a good precedent to start. If it were me, I would be afraid to call the sheriff's office for fear that the financial consequences would come back on me, regardless of my good faith or not. I mean, if I have a pure heart and I'm not going to be facing a false police report, why in the world would we impose penalties on me just because the sheriff's office, in their exercise of excellent discretion, just says we don't think we can pursue this further? The other thing is there's not parity in the situations, because that case will never go to court. The court will never be able to impose those fees, so the way it's drafted doesn't work. But on the flip side, if you look at the way it's currently drafted, the person who's being held responsible as the dog owner has violated county ordinance. And we are requiring, like in many instances, if you violate an ordinance, you pay the court costs, basically. That's the process. We don't ever flip it back around and say, oh, well, we're sorry you were wrong, but here's our bill for, next time. We hope there will be a next time when you come to the sheriff's office. That's not a good precedent to start. We want citizens to come forward in good faith and share with us their concerns. If they're lying and acting with a bad heart, they deserve to go the criminal route and face misdemeanor charges. But I just can't imagine, because the complaint is substantiated, that we're going to start handing citizens bills for the services they already pay for through their tax dollars. So I think we need to think really carefully about whether this is a path we want to go down. If the court is this concerned over this provision, then we need to strike 27-31 from existing code and leave it alone. We don't need to start passing the costs of sheriff's investigation off to complaining citizens. It's a bad idea. Thank you, Judge.
J.P. Maxwell.
Thank you, Judge. I think perhaps wording that would make this simpler, and I would like to hear your opinion on it. If instead of it says unsubstantiated claim, if it was deemed frivolous claim by the law enforcement officer, that would give you the discretionary ability that you have in many other fields. If it's a frivolous claim and you see intent to either just, as Mr. Everett spoke to earlier, just try to cause your neighbor some difficulty or whatever, then you would have the discretion to make that call. That would take it out of, that would give people the right to make viable claims or complaints, but the frivolous ones at your discretion would have a little bit of a tag to them. And again, we're still only talking, I think, in the range of $20, $25, so not exactly a prohibitive fee for people.
Well, I'll have to I'd have to ask the county attorney. My opinion on it, if there was a case that someone made a frivolous, or not frivolous, but a intent to file a false report on anything that we do, we're not going to charge them with the county ordinance. We're going to charge them with the state law. So, and we have to prove intent. So the key word for us is that we have to prove the intent of it, which is sometimes very hard to do. So I don't believe, and Steve, you can help me out here, I don't believe we would go back towards a county ordinance if we felt strongly enough that someone was filing the false report. If we could prove that, then we would prove it under the current state law that already exists.
And
Go ahead, you're recognized.
Judge, having prosecuted a couple of those, Dallas is right. And the word, for that reason, the word frivolous kind of, I think you enter some interesting legal territory when you say that. And give when you say the officer deems it frivolous, I don't know that we want to put law enforcement officers in that position necessarily, that you want to do that. But legally speaking, I don't know if you use that word except in the context of a civil frivolous, a frivolous complaint being a kind of a civil thing.
I think the intent is just to keep extra additional complaints for a couple of reasons from my perspective. One is I don't want to overwhelm the sheriff's department with a jillion calls because a dog barked at somebody. I'm not saying somebody's going to do that, but I think it has the potential to really become burdensome. And the other part is I think the intent of the original part of this, what is part of the original wording, is so that property or dog owners and property owners would sort of kind of police themselves on the front end because they know there's an expense to them for the investigation as well as to, having to do something different with their dog. So the intent is prevention and the whole thing. And I'm not opposed to the dog ordinance at all or the animal ordinance at all. I think it's good to have some tools that you can use to fall back on and actually have a guideline for how we can handle situations when they happen. But ultimately, it'd be nice to prevent these things, not go to first bite and then have to deal with them. So my intent with the amendment, and I'm open to whatever you would offer as appropriate legal, if frivolous is not the right word, whatever appropriate legal wording would be to just give the folks who are registering the complaints the same idea of pause for thought before they file a claim that might be very, and I'm using this word just personally now, be frivolous. It might be that dog chased me and I didn't like it, but didn't cross the property line, didn't do whatever. There's a lot of places in here where I think we could have a lot of complaints that maybe it would be very difficult to follow up on.
May I?
Yes, please.
Thank you. Justice Maxwell, I think for that purpose, I don't know that a word that doesn't mirror, I think you get back into the policy areas that your fellow JPs are discussing about deterring people who make complaints in good faith. Because if you're saying, I want the same moment of pause upon the complainant that I might have upon the owner, I think you have to kind of use the same wording. And the wording that's in the ordinance now is substantiated or unsubstantiated. And the beyond that, where you really have the malice and the I'm lying about somebody's, that is covered if you call the cops and that's not true. I don't know that there's a whole lot of room between those things, I guess is what I'm trying to say.
J.P. Dennis.
It's amazing how so few dogs cause so much trouble because it's the bad ones causing it to be bad for everybody else. And that made me think of what I had a conversation today. I won't tell you about the conversation yet, but the dog on 265, what is the what has happened in our legal system? What happened to that dog? Is it back home? Is it running free again?
It shouldn't be running free. If it is, it's violating the ordinance.
It is.
It is?
Mm-hmm.
Then we need to go down there. We periodically go by, but, we answer a lot of calls in a day's time. So if.
It was a neighbor that asked me about it. It's
and-
running
and
free.
If we should get called on that, and, that's a citable offense.
But I thought, well, there's a circumstance where someone's, claiming that it's running free, and, we'd have to, she doesn't much want to start a fight with her neighbor, but she wanted me to know that it's running free. And, so, anyway, okay, thank you.
J.P. Lloyd.
Thank you, Judge. Dallas, clear up something for me. Is every time a complaint is called in, is there a cost to someone? I mean, does the person who called it, or we pay tax
You pay
dollars?
taxes.
Yeah,
I
so.
mean, we're on duty.
So this
X
cost
amount.
thing down here doesn't mean that every time you go out, you've got to charge somebody something, right?
I wouldn't think so. I mean, we're out there anyway. I think the cost factor in the state statute is that you've caused undue cost to conduct an investigation on an incident that wasn't true, and that we have to prove that you had intent to do that.
But just because you're called out, you're not billing
I
somebody.
mean, we deal with
Okay.
people every day
All right.
that
Good.
don't
Good.
tell us the truth or make stuff up. I mean, that's daily.
Okay.
It doesn't
All right.
it doesn't
Thank
have to
you.
involve a dog.
Good.
J.P. Cochran.
Thank you, Judge. The last three words of Justice Maxwell's amendment say, by the court, does not say by the police officer, law enforcement officer, by the court. This would, in my mind, mean that if it went to court and the plaintiff lost, then they would pay. Doesn't have anything to do with you coming out, making a determination. Now, there's really nothing wrong here, no harm, no foul, go home, everybody stays where they're at. But if it goes to court, the wording of the language says by the court, that's the only time that the plaintiff would ever be charged with a cost. Thank you, Judge.
Okay, I have recognized everyone. We've still got J.P. Maxwell's amendment on the books. We've got a second. We've had discussion. We're ready for Carly to call the roll. Carly?
Tom Lundstrom. Eva Madison.
No.
Sue Madison.
No.
Joe Maxwell.
Yes.
Gary McHenry.
Yes.
Joe Patterson. Butch Pond.
Yes.
Bill Ussery.
No.
Daniel Balls.
No.
Harvey Bowman. Rick Cochran.
Yes.
Robert Dennis.
No.
Lisa Ecke.
Yes.
Ann Harbison.
No.
Sharon Lloyd.
Yes.
Sorry. Yeah, that's it.
Is that a tie?
I have 6-6.
That's not close, a tie, so it fails.
If I vote a 6-6, the amendment fails.
So we're back to the original ordinance. Yes, you're recognized.
Thank you, Madam Judge. I would like to speak on the ordinance before us. In consideration of the public comments that we've heard tonight, I first want to point out that Washington County has been changing fairly dramatically. Some of us don't like it. Some of us just have to tolerate it. But it is not an exclusively rural, underpopulated county anymore. There are subdivisions out in the county that are more densely packed with houses than the subdivision where I live inside Fayetteville. We can't do much to change that. Farmers sell their land, they have a right to sell their land, a developer comes in and plants a bunch of houses. So I think that is something that we need to consider. And the public roads and the public trails in the county are available for use by the public, by residents, by visitors, and we have some obligation as a court and as a county to protect those residents and visitors. These trails are going to have joggers, skateboarders, kids on roller skates, if kids still do that, mothers maybe pushing a baby stroller, and bicyclists. And we seem to have learned a lot about the great variation in bicyclists. I remember riding a bicycle a lot out in the country when I was young. And I did live at least several times out in the country as a child. And we never had a dog. It doesn't mean that if you live in the county, you must have a dog, or if you live in the country. So I think because of that obligation to protect our residents and our visitors, we need to move forward with this ordinance tonight. We cannot have another incident like the one we recently had. I mean, that was nothing but a vicious attack by an animal on a citizen that we're obligated to protect. And we have to put some steps in place to prevent that and learn to identify potentially dangerous animals. And we can sit here and say all day long that nobody that owns a vicious dog is going to keep that dog. Well, I've had tenants that I discovered after they left that the dog pretty much destroyed the house. The carpet, the blinds, the fence. This had to have been a very destructive dog. But this family kept the dog. Fortunately, I required them to carry insurance. But remember our obligation to protect the public, visitors, guests, and residents. We should all feel safe out in the beautiful part of our county. And I'd like to see us move forward with this ordinance. Thank you.
I have Ussery, Cochran, and Ecke, but I would like to let you know the petition that was turned in when we first got here, there was 109 signatures on that petition. I just think that the court needs to know that. J.P. Ussery.
I'm sorry, would this be the time for me to offer that we look at 5-2 instead of 5-1? Can we do that, or what do we need to do?
May I speak, Judge?
Yes, please.
5-1 is, with due respect, Justice Ussery, no, because 5-1 is on the floor. Now, there's a way you could get 5-2 on the floor instead of, but it would require your fellow justices to vote that way.
Would this be the time for me to explain how 5.2 came about?
I'm going to recognize you, yes.
Okay. Okay, is that?
Yes, I recognize you. Go ahead.
Okay, I just wanted to make sure. Okay, what happened was that I went to lunch with Paxton Roberts, who is the head of the Bicycle Coalition. And as we discussed this, I realized that there are many stakeholders in this. And so we had a meeting yesterday. We met at the Sheriff's Department. We met with the bicycle people, and there were other people in there as well. And as we looked through this, there were several things that came up. And one of the things I'd like for all of us to be aware of is that when this problem first came up, I realized, I think all of us did, that part of this is a matter of communication, and there's a responsibility on everybody's part. There's a responsibility on the bike rider's part. There are some things that they can do as well as the landowners. And so in our meeting yesterday, just to give you a brief idea of what happened, there was a lot of communication between all the parties. And one of the things is that the bicycle riders, there's an onus on them, or whoever, a walker or whatever, that they're going to have to take the time, and they're going to have to identify the dog. They're going to have to, and the Sheriff's Department will have to come out, and they will talk to the landowner. And at that point, then the determination will be made. One of the things that we discovered in looking at this is an all or none initially, that either it's a potentially dangerous or it's a dangerous, but there was nothing in there to address the dog that ran out and wanted to lick you to death, but it wasn't dangerous or anything else, except from the point that if you're a biker going 25 or 30 miles an hour down the road, it knocks you over and people fall off and they break bones and things like that. And also, in talking to the people from the Sheriff's Department, one of the things they said is that many times, a high percentage of the times, once they talk to the dog owners are usually very gracious to be a good neighbor. And it's unfortunate, but this whole thing is written for people who are not good neighbors. And so one of the things that we tried to address was a way in which we could protect the landowners, or the dog owners rather, and the bicyclists as well. And what our vision is for this is, I really believe that after 6 months or a year of us, I believe that it's just a few dogs causing most of the problem. And once that's addressed, I think that this problem will be minimized. I think the bicycles will be protected, and I think the people that own the dogs, once they understand the rules, because they don't want their dogs running out in the street and being run over as well. And so we talked about some vehicles yesterday to do that. And already there are some changes made and some communication done, just as a result of us getting together and talking about this issue and what the best way to communicate it is. And so that's kind of where we're headed with this, and that's what precipitated this. And so I'd really like for us to consider this one instead of this one, and this is a result. Really, I had very little to do with this except sit there. This was a collaboration of all the people that were involved that deal with this kind of stuff daily. And there was great input from the Sheriff's Department. There's great input from the people that are out there. And so I'd like for us to consider this, and that's kind of how that came about. And I'll be happy to answer any questions if you have any other questions about that.
I've got 2 or 3 more, so. J.P. Cochran.
Thank you, Judge. In the title, we have the word emergency, which indicates that this ordinance would become law immediately. I don't feel that that is an appropriate way to give this to our citizens in the county. Whatever we finally decide on should give them some time to understand what the new rules are going to be, whatever they turn out to be. So I would move that emergency be stricken from the title of this ordinance.
I have a motion and a second to strike emergency from the 5.1. Is this correct? Yes, you ask a question. Go ahead.
Mr. Zaga, if we pass it tonight without the emergency, when would it take effect?
It's 30 days after publication, which is about 40 days from now.
But it would have
Well,
to,
but you'd have, now,
it'd
without
have to
the
go through-
emergency, you didn't say to remove the emergency clause, but without, if it's not an emergency, you'd have to read it 3 times tonight,
Suspend the rules.
or suspend the rules and read it 3
So
times.
if we don't pass it tonight as an emergency ordinance, then we could be looking at it not becoming into effect until July, because if we have to go through 3 readings plus 40 days, it could be like late summer. Because
If
it
you
would
don't
be-
pass tonight and you don't call any more meetings, that
it would be the April meeting, the May meeting, the June meeting,
It's
and
actually
then
probably
40
August.
days. Yeah. And I think the people who are outside right now would prefer that we moved a little faster than that. Thank you.
Okay, now I've got several to recognize.
Judge, now we're on Justice Cochran's amendment, which has been seconded.
Okay. Yes, Steve, he's going to want to ask you a question.
Judge, Steve, you bring up a point. I was unaware that I needed to pull Article 4 out of this ordinance, and that was my intention, to not make it an emergency ordinance, so that it would have a period of time before it did come into effect. So that is what I meant to bring as a motion.
And then your second would have to agree to that.
Okay, so you're, okay, now I'm a little, okay. Tell me what we're voting
The
on.
motion on the floor now is to strike the word emergency from the title and strike Article 4, the emergency clause.
Where's Article 4?
It's the last.
Your emergency is always the last paragraph. Yeah. Okay, thank you. Okay, I'm going to go ahead and recognize you. Go ahead, J.B. Madison.
Thank you, Judge. I want to speak on the motion to amend. And that's, understand that's proper, right? I'm not bumping ahead of anybody.
Okay, no.
Okay. Thanks to J.P. Dennis, we considered that there was enough urgency to getting this ordinance passed and on the books that we scheduled this special quorum court meeting tonight. We didn't wait till next month to do it. We've had the expense of an extra meeting. We've heard from the public. There have been newspaper articles about this. There's probably been Facebook posts about this. So there's been a good bit of notification. As we move into the summer months, the spring months, with delaying this, we're going to have more joggers and more bicyclists and more walkers along our public trails and roads. And we will have sat by and done nothing to address a potentially dangerous situation. If we pass this tonight, it will go into effect immediately. By the next quorum court meeting, there could be a proposal to amend it. We're not slamming, closing a door forever. The law happens to be changeable. I remember somebody told me, a law professor once told a class that you have to stay current, the law does change. So we are not setting anything in stone tonight if we pass this ordinance. We can consider J.P. Ussery's amendment next month. We can hear more comments next month. But we will have done the responsible thing and taken some steps to protect innocent guests in our county, whether they're resident guests or visiting guests, but that happen to be using our public roads. And we do have dangerous animals in the county. We wouldn't be here tonight if we didn't acknowledge this. So out of respect for J.P. Dennis's well-thought motion to have this special meeting just to expedite this and take care of this, I think we should defeat this motion. Thank you, Judge.
Okay, now I've got J.P. Ecke.
I was just talking to somebody today that you should never make a decision when you're all emotional about it, and I don't believe in tweeting, Twitter, or anything else, or Facebook, because sometimes you make decisions or you say things in an impassioned state and you wish you could just reel it back in. My comment that I wanted to make is, it is my belief that human beings are above dogs, cats, or pets, and I value human beings, human life, more so than I do a dog, a cat, a lamb, which I've had. I was a country girl, raised out in the country, just our house and our neighbor's house. Had dogs, and you got on our property, they barked and wouldn't let you out of your car until one of us was outside. So I understand all of this, but we are human beings, and we deserve the protection of one another, and I think we should protect one another. I think the Everetts, you're great neighbors. You really are. You're the example of what we want neighbors to be. I know that our dogs never ran after somebody and chased them or mauled them or bit them or anything. They stayed within our property. But I don't think it's about y'all. I think it's about those neighbors that are not good neighbors. I think it's about those people that are not being responsible pet owners. You all are, and you're to be commended. And it's causing great injury to human life and to human beings. And it is terrorizing children that go out and walk or ride their bikes or being strolled by their mothers while they're jogging. I don't like to pass anything quickly, and the emergency and the urgency, because I think we need to think about things. There's a lot of things that was in here that was edited and laws on the book that I'm not familiar with. I would like to hear what Justice Ussery's amendment is, but I think we need to pass an ordinance that does protect human life, whether you are a biker or walker or whatever. And I don't believe that we are acquiescing our responsibilities or duties. And I do take exception, Justice Madison, for saying that we are passing the buck and not taking this responsibly, because we are. And it's because we wanted to really read this without all of the edits and additions and changes that were being done last time, and we wanted to hear from other people. And I did. I heard an earful, believe me, from people that were mad because it wasn't passed that night. And how could you? And when I shared with them, I said, we need to make an educated decision. And I didn't have all the facts. And until we make an educated decision, I don't feel comfortable with doing something and putting it on the law. And I think that they respected our position. Well, that's not what we understood. And they respected and valued, perhaps a little prudence was necessary. Just a minute. Let's make a wise, good decision and not an impassioned, emotional decision. I think this is good. I commend you, Justice Eva Madison, for doing the work that you did. I'm going a little long. Human beings will always go above any pet or any dog or any cat or anything, because that is sanctity of life. So I'm going to support an ordinance, whether it's Justice Ussery's or the Madisons. one way or the other. Thank you for your time and your forbearance with me. Thank you.
J.P. Pond.
Yes, ma'am, I want to make sure we're still talking about the amendment on the table. On the floor now is to strike the emergency clause. Is that correct? And
I was addressing it, if I may, because it is an emergency. Human life is valued, and a day that goes by that we're not protecting human life is not. So I was on topic. Thank you, Judge.
Yes,
ahead.
ma'am, and I did not move to, I didn't do a point of order on you. Okay. I wanted to point out that at our last meeting, which I'm very much appreciative that we're doing something about this issue, but at our last meeting, the reason that I voted to table was to give the public more time to come in and give us input. Didn't have anything to do with not wanting to get something together, and I've already complimented Ms. Madison's work on this, and I do appreciate it. But as you can see this evening from the public comment, it was really a good idea to table because we had not given the public time to come in. The people that actually live in the county, that own the property, that own the dogs, and I'm glad that we did. And at the same time, I want to agree with Ms. Ecke and her comments. We do need to give this enough time to get this right. And it doesn't necessarily mean that it's going to take 3 months because we've got to do 3 readings. Because when we do get it right, and it's not, and still, when I say get it right, does not mean it's going to be perfect. Men just don't make perfect laws. But we're going to have something that everybody concerned can live with. And I expect more input from the public, the public that was here this evening. So I'm in favor of striking this emergency clause, but that doesn't mean that I'm interested in dragging this whole thing out for 3 months. We can make a motion later on to suspend the rules and do extra readings by title only. Steve, that'll give you a break. So, thank you.
J.P. Harbison.
I want to go back to what Captain McClellan said. I said, what was the difference in what we have on the books now and what we're voting on tonight? And he said, if I am correct, he said the only difference is that the animal owner has due process. So we really do have protection for humans out there with the Sheriff's Department now. We're doing this for the Sheriff's Department so that they can enforce and take care of the dog problem. They have more dog calls than they have anything else in the county, and this has always been so. So, taking the emergency clause off is, not a big deal, because when we say, oh, we've got to pass this because we don't have any protection, we do have protection. We've got the old ordinance. The only thing we're trying to do is to strengthen that ordinance, and it seems like the more words we do, the deeper we get. And I think the fewer words we use, the better off we are. Thank you.
J.B. Usry.
I'd like to call for the question.
Second. I have discussion is ended. And now, okay, would you please tell us exactly what we're voting?
Actually, you can vote on it, but if nobody is sticking their hand up, debate may be over naturally anyway.
No, I don't have anybody else
Okay.
on the list. So okay, are we voting on?
You're voting on Justice Cochran's amendment to strike, I'm sorry. You're voting on Justice Cochran's amendment to strike the word emergency from the title and Article 4 from the ordinance.
Does everyone understand that? Okay. Carly, call the roll.
Tom Lindstrom, Eva Madison.
No.
Sue Madison.
No.
Joe Maxwell.
Yes.
Gary McHenry.
Yes.
Joe Patterson. Butch Pond.
Yes.
Bill Ussery.
No.
Daniel Balls.
No.
Harvey Bowman. Rick Cochran.
Yes.
Robert Dennis.
No.
Lisa Eki. Ann Harbison.
Yes.
Sharon Lloyd.
Yes.
By a vote of 6-6, the motion to amend fails.
Okay, JP Ussery.
I'd like to make a motion to amend 5.2 and substitute 5.1 and substitute 5.2.
Second.
I have a motion and a second to substitute 5.1 to 5.2. Is that correct?
Yes, ma'am. And if it's okay, I wouldn't, if we could have somebody from the sheriff's department come up, maybe Dallas come up, could you come up and kind of explain what it is by adding, what we want to do is that the main thing in this is that with all of the appropriate people there, we kind of, it fell into, we went over this as well as the other things. And there was a reason that we wanted to add that third layer in there because it's going to help law enforcement to do a better job because it was going to tie their hands the way it was. And so that's why we did that. So anyway, that's why we want to do it. And we'll vote on it, whatever we need to do.
Okay, JP Madison, I'll recognize you before we let Dallas start explaining for us.
Thank you, Judge. And I'll point out to J.P. Pond that men may not pass perfect laws, but the women do. No point of order. No. Sorry, it was.
Hey, Dallas, you come back here.
Yeah.
I thought he was leaving us.
I'll say this. I saw, I think like many of us, we saw J.P. Ussery's changes for the first time today. If we're concerned about doing things in a hurry, I'm concerned about making a change that's this significant this late in the game. I would like to see us put the changes in 5.2 on hold, not hold things up, but delay the discussion so we can get input. I'm concerned that we're trying to address with 5.2 the fact that we don't have a leash law in the county, and I think that is something that most definitely warrants extensive public discussion. And so for an ordinance that was not publicized, was not posted, was not on the agenda, I don't think this court should be passing that tonight. I think we should focus on 5.1 and work to perfect 5.1 as we go on and consider 5.2 that JP Ussery and all the folks in the meeting last night were involved with as a great starting place. But if all of us are concerned about getting it right, then we don't need to be passing something that we all read for the first time this evening. So I commend you for the work you're doing. I think it's important that we consider that third category, but I also think that's part of the bigger discussion about a leash law. Because we're talking about putting restrictions on a dog that is free to roam because it might lick someone excessively. I really need to think about that. And I think this court should think about that. So I can't support the amendment. That doesn't mean that I will not ultimately support the concept, but I think we need to explore this issue like we've explored the heart of 5.1 already. Thank you, Judge.
JP Ussery.
And that is exactly the reason that I've asked these people to come forward and talk, so that we all can have an understanding, because I thought yesterday we had that between all of us, I think a lot of things came to light, and I think that if we can discuss that tonight and take a few minutes, I think that will really help to clarify these things and help us to understand how this came about. So if that's okay, would you go ahead and explain kind of how this...
Hang on just a minute.
I'm
JP
sorry.
Madison.
I'm sorry.
Thank you, Madam Judge. I didn't see this till I walked in here tonight, and I haven't read it because we've been discussing other things, so I don't know what's in this at all. I don't spend all day long glued to a computer. But as a procedural matter, I'm a little bit confused, and I request that our county attorney kind of straighten me out if he can. 5.1 has two sponsors, JP Eva Madison and myself.
That's correct.
Now, can another JP amend
Yes,
a
ma'am.
potential ordinance without it ever having to go back to county services again?
Yes. They can do that at a regular quorum court meeting. Yes.
Without consent from the sponsors?
I
And
don't know
then-
how they would get that without violating FOIA, without doing it at a public meeting. But, so the answer is yes.
True. But then if the sponsors decline to continue sponsoring it, how might the ordinance continue with no sponsor?
It's still, well, if it passed, I don't know that sponsorship is a legal requirement for an ordinance to pass. And if this court were to vote to pass the ordinance tonight, it would pass, it conceivably could pass without a sponsor. I don't think it has to have a sponsor. It's a novel question for me, Justice Madison. I've never considered it before.
Well, my previous experience was if a sponsor decided to pull a bill down, that was the end of it.
And that, by the way, has
I'm
been...
not suggesting that that happened.
May I?
Yes.
Okay. Two things. The custom of this court, which is, has been a deviation somewhat from Robert's rules, has been to allow a sponsor or sponsors to recommit on their own or pull down an ordinance on their own. Okay? Now, really, by Robert's rules, that requires permission essentially from the body. There's a motion specifically tailored for that purpose. Having said that, the reality is also that, and I don't think this is Justice Ustry's opinion at all, but a frequent parliamentary tactic is to amend a bill, as I'm sure you experienced in the legislature, to the point where it is unpalatable and unpassable. So, and including to the sponsors. So, yes, it's completely procedurally appropriate for Justice Ustry to do this tonight, and if either of the original or both of the original sponsors were to say, I don't want this bill, this ordinance now to pass as stated, if your fellow justices disagree with you, I think it becomes law anyway.
Okay. We're going to go ahead. Are you ready to recognize Dallas?
yes, ma'am.
Dallas, if you will proceed, please.
We were invited, first off, myself and Mr. Roberts, we had a scheduled meeting yesterday at 1 o'clock before the meeting that happened with J.P. Ustry. That meeting was to discuss the reporting system that we were intending on using if this ordinance was passed. One of the reasons was because of the due process for the dog owner and the higher stakes for a dog that was going to be deemed potentially dangerous or dangerous, that we felt that we didn't want to get anything wrong. So a cyclist, a walker, whoever would have to come out to the scene and say, that's the dog right there. That is the dog that chased me. That is the dog that tried to bite me. During that conversation, Mr. Roberts brought up the fact that, you know, that there was dogs that actually chase. They just chased because it's fun. That they weren't going to try to, they didn't get into a situation where they were trying to wreck them or try to bite them. And he made a comment about, you know, those dogs, us just giving those people a warning about their dogs coming out on the road. And the conversation started dialogue to the point that that wasn't an option that we saw in the current ordinance. Because even though what one person may think of a dog running out and running beside them may be something else that someone thinks that dog may wreck them also, which from what we understood from talking to Mr. Roberts, that there's more wrecks caused by dogs than there are bites. So that got the conversation brought up about hazardous dogs and not putting those dogs under the same umbrella as potentially dangerous. Because if you deem one potentially dangerous under this new ordinance, they have to be spayed and neutered, they have to be microchipped, they have to be put in a kennel, and they have to go to obedience school, and there was a list of other things that were very costly to a dog that may not have been aggressive at all, but he could be the potential. And there was no warning system to warn a citizen or warn a dog owner that, hey, you know, your dog's getting out on the road and it may cause wreck. So that brought up the conversation of where we're at now with the first tier, which would be a hazardous dog. that nobody, even the complainant would call in, didn't think the dog was vicious. The dog never tried to, nip at the tires or anything like that. And that way, the dog could be deemed hazardous. The people would be warned of that. If another call was called in by the dog, then law enforcement would take the next action and deem the dog potentially dangerous. Is that correct? Is it?
Yes, that is correct. And then one other thing that goes along with this is that dog will be chipped, microchipped right there. And because they keep track of the dogs, and so the second or third offense, then that dog would move to the next level, whatever that happened to be. And so we felt like this was a way that they would give them an opportunity to warn the people that need to be warned, instead of having to come out and very first crack have to have. I mean, the dog runs out in the street, and they're coming in, they're saying that you have to have the dog spayed and neutered and all the other things, and you're going, the dog just ran out in the street. So this gives them a little bit of flexibility to do that, and that was how all this came about. So thank you very much, Dallas.
Excused.
Thank you, Dallas. So where are we on this? Does anyone,
Discussion amongst the court, Judge.
do we have any discussion? J.P. Cochran?
Thank you, Judge. I just got to read this today, as all of us did. And looking at it, this extra layer does have merit in my mind. It doesn't necessarily constitute a leash law, as has been suggested, but it does make the owners of dogs that tend to roam and get in the way of other people on the road, on the street, or one of my constituents who is in her 60s and has a friendly neighbor dog that wants to knock her down. When the owners don't care, they say, there's no leash law. We can do whatever we want to, and it's on her property. So as I read through this, it looks like that would cover that situation as well. Not only just a walker, somebody on their own personal property with a stray dog that has an owner that's identifiable. And I do like a lot of the language in here. One of the things I noticed on page 2, in the first paragraph, bottom of the paragraph where it's underlined potentially dangerous or dangerous animal, we probably ought to make that go dangerous, potentially dangerous, or hazardous to pick up all three categories. I think that's just an oversight there, and I would offer that as a friendly amendment to your moving 5.2 onto 5.1 if that's appropriate. Is that an appropriate motion, Attorney Zega?
If it's accepted as a friendly, yes.
Yes,
Okay.
absolutely.
Okay, all right, thank you. One other,
So what, now tell me again
Okay.
what you just said.
on page 2, first paragraph, where it's underlined says potentially dangerous or dangerous animal, we basically missed one of the categories, and if we've changed it to read like the title, it would be dangerous, potentially dangerous, or hazardous. That would cover all three categories.
Okay,
Okay?
so just, go
Right.
ahead.
Okay. And one question I had on page 3, when we talk streets, does that include our county roads? Is a question in the interpretation, I think, for Mr. Zega. Or do we need to say or road, street or road?
We talked about this somewhat in committee, and the words "off the owner's property." This is goes back to Justice Maxwell's and Mr. Everett's point in the beginning. You could define it to say county roads, and you could insert that in either 5.1 or 5.2, that language, but you need to say it, I think, across the board.
Right.
Pardon me. But my opinion is that it covers, this language now covers public rights of way.
Okay, thank you. That's all, Judge, thank you.
Deputy Madison.
There's an addition on page 4 about livestock being exempt, and I don't know why that's not in the definitions exception, because I'm trying to figure out what the impact is of having it appear in one place and not in the definitions. Because domestic animal excludes livestock by definition. And then the state law governs what happens if a dog were to attack livestock, and that's addressed by 2734 on page 11. But I mean, I'm not sure we're going to have a lot of aggressive cows, but,
No, the point, Justice Madison, for that was if you don't have a lot of aggressive cows, but you do have cows that wander into county roads and park there and keep people from driving down the street, and you don't want them microchipped and then deemed potentially dangerous and you don't want them on the elevation, the
Okay.
escalator.
well, this has given.
That was the point behind that particular.
I guess this has given me pause then, because, I mean, again, this was based on the state law that was provided to us from Benton County, Washington, that was actually Washington state law, but it's made me wonder, what is an animal then? Because the definitions for hazardous animal, potentially dangerous animal, and dangerous animal are animal. And that excludes livestock, which, according to the amendment, I'm just trying to think how this all fits, because I don't even know what some of these species are. They're listed, and that's the existing definition. But I'm just trying to fit that all together. If we're going to exclude livestock, then do we need to limit the definition of animal to domestic animal, which would already exclude it? Because we've defined domestic animal, we've defined livestock, and they're mutually exclusive. So I'm puzzled now because of the exclusion that appears in a non-definitional section that is attempting to be a definition. I'm just wondering if that's the best way to handle it. Sorry, that's kind of lawyer technicalities, but.
J.P. Harbison?
Livestock is covered under other state law. I mean, livestock, we don't have open range laws. So, apparently, so I think it needs to be put in there for clarification. Thank you.
It is in the definitional section. I mean, it's not in the animal it's in the exclusions, so.
I just want to make sure it doesn't need to be somewhere else, or if it worries me if it's made it unclear somehow.
Steve, what do you think?
Well, the entire purpose of that was to keep somebody's chicken or cow or pig that got loose from a pen
From getting spayed or neutered.
and microchipped and put on the escalator to
Right.
dangerous animal, and potentially euthanized. That was the point. If it,
Well,
putting
I'm
it
not,
elsewhere in the ordinance seems to me not to be that big a deal as long as it's in the ordinance somewhere.
but it says livestock is by definition exempt from the definitions of hazardous, dangerous, or, that's what's confusing. It's the by definition. I don't know what that means, because it's
Well-
not defined that way.
Then you could strike the words by definition and just say livestock is exempt from the definitions.
Okay, that probably is better, because I kept trying to go back to the definition of livestock and couldn't make that make sense. Okay, thank you. Sorry for the confusion.
No, it's my fault.
So what are we striking?
Well, it's
don't know if
not been moved yet, Judge.
Okay.
I would offer that to JP Ussery, just a friendly amendment to
Yes,
strike by
ma'am, that-
definition.
I think that's a good idea. Thank you.
Okay.
So you're striking the words by definition from,
Okay, so do we need to take a vote on that, don't we? Or do
no,
we?
the amendment was accepted by the,
Okay, by the author of it, okay. Any other comments? Yes, J.P. Maxwell.
My concern is that, not with this 5.2. Excuse me. Thank you, Madam Judge. When I look at, I'm looking at page 3, it almost looks like if you're a dog, you're guilty of one of either a hazardous animal or potentially dangerous animal. if you just approach somebody without menacing. My concern is that we're making this so broad spread that we're going to create ourselves a very cumbersome job. I like the intent, but I think most dogs are going to be guilty, and they're all going to be in this process if we're not careful. I'm also looking at Part B of potentially dangerous animal. It's any dog that chases or approaches a person upon the streets. I'm having a hard time understanding how we're gonna decide what a menacing fashion is or an apparent attitude of attack. I see a lot of subjectivity in there, where if we lean to a very open sense of that, we're gonna have a lot of dogs and a lot of process, a lot of animals that could be interpreted to fall under this. So I guess I'm just voicing my my observations is this seems very, very far-reaching. I don't know if that's the intent of it, but that seems like what maybe the law, if we pass this, is going to have that effect. Thank you.
Jeff Yessery.
One of the things that we discussed yesterday with the law enforcement was how to word this in such a manner that their hands would not be tied, that they'd be free to do what they need to do. And that was kind of how this language came about. That's going to be up to the law enforcement person that comes, and he's going to check that out, and then he will make that determination. And the onus is completely on them. But they have some guidelines and things that they use so that they're real consistent in doing that. And so that, again, that will be in their, that will be up to them to define how they do that. But they seem to be comfortable with this yesterday.
J.P. Harbison, you had your hand up, didn't you? Oh, okay, J.P. Ecke.
I commend you, Justice Essery, for doing the work that you did in meeting with the Sheriff's Department and the Bicycle Club. I like that it's broad and it is subject to interpretation by the law. I like our Constitution, the way it's written. You know, it's broad, so that way it encompasses what it needs to encompass, and there's the law. I support it. I like it. And I wanted to say thank you. Thank you, Madam.
J.P. Essery.
I'd like to make just one other comment, and that is I feel very humbled by getting everybody together what got accomplished, because not only did we get this accomplished, this was almost a sidebar to what else was accomplished, and that was the fact that we were able to communicate and because we were finding it to be very awkward as to how this could be communicated to the Sheriff's Department. And as we sat there and we discussed, well, it came out as part of the discussion that if the biker will just take his smartphone and do 911, they will know exactly where he is. They may not know where he is, but they will know where he is. And they even are going to be doing some training on how to make sure that that gets carried out and what the process is going to be. And so I'm very grateful for everybody that was involved yesterday. Thank you very much for all of your help.
Go ahead.
It's just a follow-up. That was one of my concerns when I did move to table this, was how is law enforcement going to carry this out? How are we going to communicate? And so some of the words that you're using were some of the concerns that I had last time we met, and thank you for answering that, and now I know. But another thing is, how are we going to get the pet owners? How are we going to communicate with them?
Okay, go ahead.
Okay, and that was another thing that came up, and that is that they're already taking steps. They have a form that they're going to give the pet owner. And when they give them a warning, it'll be a form, and it will say, these are things you agreed to, and they'll sign it. They'll have a copy, we'll have a copy. And that name will go into a file. And then if it comes up again, and if those people, and the reason that the dogs are microchipped is because if those people move, which they do frequently, especially the people that have the dogs that cause issues, as they move around the county, that dog's microchipped, and so they move someplace else, well, they go, this is the third strike on that dog, that's it. And so that's a way for them to kind of keep up with that. And so, like, again, I said there was a lot of very good discussion yesterday on
J.P.
what we're
Cochran.
going to do.
I want to comment on page 5. Section B, as in boy, the last words, or vending machine. Do we have any vending machines that we can tether an animal to in the county? We do?
They won't find anything.
Okay, well, I'm just wondering why we used the vending machine as opposed to,
Refrigerator.
yeah, but do we need to mention refrigerator, truck bumper? I'm wondering if we've opened, and this is a question for Mr. Zaga, have we opened the door to something else?
That's an example phrase. I don't
Okay.
think so. It's don't tie the dog to an inanimate object.
Okay, okay. I just thought it was a little odd. Thank you, Judge.
Okay. J.P. Harbison.
I just want to emphasize that will take effect if your dog is in the road. If it's on your property, it will not, you have nothing to worry about. It's only those dogs that are running on other people's property or on public property. So if you live off the highway, this ordinance is not going to affect you. Your dogs will be fine. So, I just want to emphasize that. Thank you.
J.P. Usry?
I'm sorry to keep saying one more thing, but one of the other things is that in talking with Paxton back there, that we're going to, when this law, whatever it looks like, when this ordinance goes into effect, there will be information given out, both in the newspaper and he has a format to get hold of the bike people, that these are the things that we expect from you. And so again, it's a give and take. It's not just a one-sided thing. And so I just wanted you all to be aware of that there are some things that they're going to do, some processes they're going to put in place as well. And so we're going to do our best to make this public, and so everybody knows, and so that, again, I'd like to see it take effect as quickly as we can, just because I think everybody's going to benefit from it. Thank you very much.
Okay, do we have, I'm going to
Judge,
call for
this is-
public comment on this.
And you'd have to suspend the rules to do that because you are only on Mr. Usry's amendment. You are not on final passage of the ordinance.
Do we want to suspend the rules?
I make a motion to suspend the rules and have public comment on 5.2.
Do I have a second? Okay, I have a motion and a second. All in favor of having public comment on 5.2, say aye. Aye. Opposed, same sign. Okay, do we have anyone that wants to comment from the public on 5.2? I give you your chance. Thank you very much. Then we'll, yes, come right on.
I just feel the need to at least speak briefly about this whole process. I know that we caused it. We didn't cause everything. An event basically caused this, and I think that one of the things that I talked to Mr. Everett out in the hall about, I said, if a lot of this wasn't surrounding an incident with a bike rider, I don't know that some of these people would be here today. I think that I think Mr. Paxton Roberts has his hands full on a PR issue that he needs to work with his folks about building better relationships with the people that they're coming out into the county to deal with. And we've talked about that, and he agrees that there's give and take on both sides. But what we've asked the court to do for us in law enforcement is really more about expansion and clarification of an existing ordinance. We've basically taken the existing ordinance and just tried to make it a little bit better and more enforceable. My desire was this, and it was that to kind of do away with this first bites free nonsense. And the only way that I felt like we could get there was that if we had a measure in the ordinance that basically allowed us to receive information, talk to a dog owner, but prior to somebody being bitten, give them this information about what the expectations were. And then if they don't abide by that, then we go to the next level if we get a second call. The reality is the Hardens, have we ever talked to y'all about your dogs or anything? And, well, Beth Everett we have because she's a troublemaker.
My dog
but,
has no teeth.
her dog gummed somebody. But the reality is, if we have the ability to talk to responsible property owners and animal owners, they're going to do the right thing, okay? And that's our desire, is to get in on the front end, to develop a communication stream to where we can get involved early and put people on notice that there's been a complaint filed, please be aware, and here are the expectations. And that allows us to go to the next level whenever an actual vicious attack occurs, and we can really leapfrog then. So it is my belief that if it was not competitive bike racers involved in this, we probably wouldn't have quite the anger about this whole thing. Because in reality, if you'll remember 2 years ago, I brought this forward, it wasn't about bike riders. It was about a lady that was jogging and with her kids in a stroller that was attacked by a German Shepherd that came out of a house, and we really didn't have the ability to do much different. But anyway, I don't know if that helps you in anything, but I appreciate the work that's gone into this. The meeting with Bill was about communication, trying to get information out, and how are we going to get people to report, and it morphed into a more meaningful discussion about the ordinance. Now, is it perfect? No, I don't think so, but I think it's good. I think it's probably the direction we need to go in, and then we can build on that as time goes by. So those are my comments. So thank you.
Mr. Zaga, can I ask if we amend it and we substitute 5.1 with 5.2, where does that leave us procedurally? Because it had come up today. Does that cause us any issues?
You would, well, if you amend it, then you're on first reading. I would need to read 5.2, hopefully by title only, although if you want me to read the whole thing, obviously I will. Then it would take a motion to, well, it would first take a motion to pass it with a second. So it would.
But the fact that it wasn't on the agenda is not a problem. That's what my concern was. Because I'm about willing to pass it on, but I'm just trying to think about the notice aspects.
Well, it doesn't make it illegal. It makes it, and as you well know, I've said before that I think the public deserves, from other aspects of discussion, y'all need to be careful about how you don't let the public know about what exactly in substance you're doing ahead of time for them to have meaningful input. It would not make it an illegal ordinance if you did that, if you were to pass it tonight.
Okay, thank you.
Thank you, Judge. I haven't heard any of us talk about how we're going to address the 109 signatures on the petition that we got. I mean, all those people need to have a say. I just feel like that if they went to the trouble of 109 of them signing a petition against this ordinance, I know we've received lots of emails, but I don't think we've received 109 emails for it. I just feel like that, and may I speak to JP Esri? Yes. Was someone that was against the ordinance, were they involved in 5.2? Or was it just the cyclist? Yeah, that were against 5.1, but I mean, were they involved in the production of making 5.2? I mean, was anyone, I realized that it was the sheriffs, and I realized it was a cyclist organization, but did we have someone of this caliber, of one of these 109 folks?
We did not have one of the 109 people at the meeting.
Did we have anyone that represented that they were against the first 5.1 and that they wanted to modify 5.2 or add to? Did we have someone in that way? And just for clarification, I mean, I'm for an ordinance. My daughter was bit by a dog, so I understand all that. But I want to make sure that we also address 109 citizens of our county.
I can just tell you that I talked to a number of citizens, and without exception, when I explained to them that with what we were doing here, that it would not affect the average guy out there, that if his dog stayed on his property and if he did the right thing, this is only aimed at the people who are not taking care of their animals. And every time I explained that to them, they said, oh, I understand. And they also, the one or two people I talked to said that it would help them in addressing some issues they had. They were just concerned that, it was going to affect everybody. And once they figured out that this was just aimed at people that were specific people that were having issues, everybody was in agreement. They didn't see
And
any
these
issue
were
with it.
folks that were initially against the ordinance, correct? Is that
Yes,
what
ma'am.
you're saying?
Yes, ma'am.
And they, once you explained it, they seemed to?
Yes, ma'am. Absolutely. The same thing that Mr. Dennis said, I believe.
I'm going to take a liberty here. The folks that are sitting out here that has appeared tonight to speak against this, do you guys have anything? I know you have not had the opportunity to see the 5.2. I'm sorry.
I know y'all have not had an opportunity to see the 5.2, and you are the ones that brought the 109 petitions in. Do one of you guys want to speak on this? Do you have something to say about it? John? Come forward. Come forward.
I've pretty well said my piece. I don't even know what 5.2 is.
Well, okay,
Is
that's-
it that
okay.
hazardous animal addition to it? I mean, my whole observation from listening to this is, and I believe Mr. J.P. Usry, or whatever I have to call him, that this is designed not for the guy that does the right thing, but for the one who does not do the right thing. The problem with the law is that it's permanent. You might think that's the purpose, and it may be the purpose, but it may not be the purpose next year. I'm told, for example, that you lost your race for, I don't guess you ran for county judge, for whatever you ran for. I mean, there may be a whole different body of people here. There really may be, and the bikes may be rocket-powered in 10 years, and I don't know what to do about it. If it's as simple as a matter of saying, well, we just want to address this to people doing the right thing, then I think Ms. Harbison has the best point. Make it this big instead of this big. Pass an ordinance saying the sheriff has discretion to label a dog this, or this, and whatever the sheriff wants to do is okay. What's wrong with something like that? Because that's what, when it all boils down to it, that's what everybody says this in effect means, but that's not what it says. The potential dangerous dog deal or the hazardous dog deal, if you read that strictly, like lawyers read things, they read it this way, every dog is hazardous. If he approaches you or chases you, whether he does it menacingly or with an evil intent, however you figure that out, make any difference. As long as you're reasonably in apprehending physical injury or something like that. Well, I might reasonably apprehend physical injury, and Eva Madison may not. It doesn't make any sense to me to try to write this elaborate of an ordinance to address to people who will not do the right thing, because I think what you're doing, as long as Tim Hilder's the sheriff and Dallas McClellan, who's my neighbor and my friend, and I trust him with all I believe to be holy, each one of them, as long as they're in charge, suits me. I don't care what you pass. But they're not going to be in charge forever. And if you read these ordinances strictly, I think you're creating a nightmare for people, even people that do the right thing. And the reason I do is because, not the dangerous dogs are different. For dangerous, you ought to go shoot them. But potentially dangerous dogs is so loosely defined that it's going to pretty well be up to whatever the guy riding the bike thinks. And I don't want my dogs to be susceptible to whatever the guy riding the bike thinks. I don't want to have to be annoyed with the sheriff coming out there and trying to figure out if I got a potentially dangerous dog because Zega's riding the bike in front of my house and they ran around and chased him and he thinks they had a menacing attitude. I don't want to have to appeal it to the county court. I don't want to have to hire a lawyer and appeal it to the circuit court. I don't want to do any of that crap. But that's what you have to do under this ordinance if you read it strictly. And that's my only objection to it. I mean, Eva's done it. She's a good lawyer, a great lawyer. And she's written it like lawyers write things. And maybe that's the way ordinances have to be. But to say on the one hand, well, we're just trying to do the right thing. On the other hand, look at that ordinance. They don't match up, folks. I'm telling you. They'll read it in your quiet moments. Read it tonight.
Thank you, John.
That's all I have to say.
J.P. Madison.
We're actually circulating the petition, and I took a look at it. What's difficult to ascertain is why they oppose it, if there's a particular part of it they oppose. And it's also, you can't tell where they live, because we had one gentleman that came last time who lived in the city of Fayetteville and was opposed and wouldn't be subject to the ordinance. So it's a little hard to figure out. It'd be helpful to know why they opposed and what their motivations were, because you just get a name, and in some instances, a city, not even address. So I mean, as it makes its way to you, you can look at it, but it's a little hard to tell. I wish we could get constructive criticism, like Mr. Everett has come forward and said, these are the problems I have that we could try to address. Otherwise, it's just hard to know. That's sort of the drawback with petitions, is you don't get any independent feedback. So, but it's making its way around.
J.P. Cochran.
Thank you, Judge. Well, as it makes its way to Attorney Zaga, when it does get there, I was going to have Attorney Zaga read what they were signing, what the top of the petition says. The identification issue is another issue, but I'm curious, and for the folks that are at home and folks in the audience, what does it say, and what were they signing for? Thank you.
J.P. Lloyd, did you have your hand? Yes.
Yes, thank you, Judge. Well, in response to Justice Madison's argument there, then if we want to get input from 109 people, then we don't make it an emergency and pass it tonight. I mean, we give them opportunity to come, and 109 or 9 or 10 or however many want to show up from there and speak their mind. I mean, if we don't know, we can't tell from the signatures what their concerns are, then we need to give them the opportunity before 5.2 is passed to have an opportunity to read it and then come and speak to the court, have citizen comment. Thank you, Judge.
Thank you. J.P. Ake.
Thank you, Madam Judge. I would like to ask the people who brought forth this petition, who circulated the petition, what exactly did you communicate to those signing the petition?
I'll speak to that. Here's the problem.
No, what exactly did you say to them when they signed it?
I didn't say anything to it. I didn't circulate it. A guy in the back of the room, his name was Joe Ferris, I think, gave me this petition because I guess he sensed that I either was stupid enough or bold enough to talk to you, and by that time I'd run out of my 3 minutes.
Okay, so you're not the one. So you're not the one who went door to door.
No, I didn't even know it
well,
existed.
Then,
I don't know.
Yeah, but this is.
I don't
let's,
really.
Now, let's keep decorum here. So.
Thank you. I appreciate it. I mean, I thought you were the one who presented it to us. Well, then that sheds just a whole different light on. I thought it was by these people that are represented here. I would really feel good about passing this emergency ordinance 5.2 the way it's written tonight on the behalf of the citizens out there and for their safety. And it's also a response. If I had a kid that went out and chased and knocked down somebody, I'd be held responsible. But if it's a dog, then I should be held responsible and liable for whatever happens. It's the same thing whether you have a child or if you have a dog. You're liable. And I think we should just pass this. Thank you. I mean, the person's not being represented who dropped it off, so we don't even know who it is.
They knew what they were signing.
Well,
Yes,
in fairness, he
what
stayed
they
for a
said.
long time.
Judge, you gotta bring the chamber.
Okay, guys, come on. Let's don't be talking until you're recognized. Okay, the next person I have on the list is J.P. Harbison.
I can tell you why these people signed this, because country people don't want to be told what to do, and they don't want to be told to tie their dogs up. You know, this is a culture. I mean, we've let dogs run loose forever, and that's why they signed it. I mean, that's the bottom line. We've got so much misinformation out there, you know, that it's unreal, you know, because I've had more calls on this, and if I run into someone, Harbison, are you going to make us tie up our dogs? And I said, no, I'm not making you tie up your dogs. Do they chase bicycles is my next question. And that, you know, well, they would if they, you know, I live near a road. But basically, everybody out in the county is opposed to this. and I say, well, we've got people that ride out there, we've got people that walk on the roads, and they need to be protected. And if your dogs don't run out and chase people, then there's no problem, So, that's, I know why people signed it, because I would have signed it if I'd been in their place. Thank you.
J.P. Ussery.
Okay, so are we ready to read this? Do we want to go ahead and, I think we've already, the motion's been made, right?
You
Yeah,
are,
Yeah, can you read the new one and just by title only? Would be
you
fine,
haven't,
Steve? Okay, so we need to adopt it.
the motion before the court, as I understand it now, is your amendment, Justice Ussery, to amend and substitute 5.2 for 5.1, seconded by, I forget.
Everybody's pointing.
It was seconded, I remember
Yeah,
that
I did
much.
too.
I second it. Thank you.
Okay, yes, J.P. Madison.
Before we adopt it or vote on adopting it, during the discussion, somebody pointed out that on page 2, there was, in the next to the last line of the first paragraph, hazardous needed inserting there, that it was if it had been forgotten, because it was in every other part of this 5.2, but nobody ever made the motion to do that.
Yeah.
Yes, it was.
There was a friendly amendment on livestock, but there was?
Yes.
Okay, I'm glad I'm wrong. Thank you.
So, pardon?
What's the vote required for an
The
amendment?
vote is a simple majority.
Of those present or the
Yes,
court?
those present.
Okay.
But, yeah, 7 passes the amendment tonight.
So now we are.
That's a motion, but I'll explain the difference when we come to if we're actually passing the ordinance.
We're voting to transfer 5.1 to 5.2. Is that what we all understand?
As amended.
Yes, as amended, okay.
But we're not voting to pass it.
No, we're just to transfer it over. So Carly, would you call the roll, please?
Tom Lundstrom. Eva Madison.
Yes.
Sue Madison. Joe Maxwell.
Yes.
Gary McHenry.
Yes.
Joe Patterson. Butch Pond.
Yes.
Bill Ussery.
Yes.
Daniel Balls.
Yes.
Harvey Bowman. Rick Cochran.
Yes.
Robert Dennis. Lisa Ecke. Ann Harbison. Sharon Lloyd.
Yes.
So we're now 5.1 has now become 5.2. So,
Okay, can we just read this by title only, Steve? The new one by title, 5.2.
okay,
Suspend the
we have
rules.
a motion to read it by title only.
May I, before we begin
Yes,
that,
please
Judge?
go ahead.
Justice Eva Madison asked if I could read only the changes. I don't know that there's, I think it's binary. I either read it or I read it by title only. So if you want me to read the changes, I got to read the ordinance.
Mr. Butler used to do that sometimes with amendments. That's why I proposed it that way. If you don't think it's okay, I just thought it might be good to read the new parts since they've not been read.
How about make that motion?
Okay, then I would move that we suspend the rules and read the new parts of 5.2, therefore the parts in red.
Did you second it, Mr. Maxwell? Okay, all in favor of reading the new part, say aye.
Aye.
Pose same sign? No. Okay, do a roll call. I didn't understand who had the most votes. I think I did, but Carly, would you call the roll, please?
Tom Lundstrom. Eva Madison.
Yes.
Sue Madison.
Yes.
Joe Maxwell.
Yes.
Gary McHenry.
Yes.
Joe Patterson. Butch Pond.
Yes.
Bill Ussery.
Yes.
Daniel Balls.
Yes.
Harvey Bowman. Rick Cochran.
No.
Robert Dennis.
Yes.
Lisa Ecke.
Yes.
Ann Harbison.
No.
Sharon Lloyd.
Yes.
They were just noisier, so we'll. Okay. So now, Steve, if you will go ahead, please.
An emergency ordinance amending Washington County Code, Chapter 2.7 in regard to dangerous, potentially dangerous, and hazardous animals. We skip down to 1, 2, 3, 4, fifth whereas. Whereas animal owners whose animals are designated as dangerous or potentially dangerous or hazardous pursuant to this ordinance should have the opportunity to appeal that designation, and the most logical forum for that appeal process is the county court with further opportunity to appeals. The circuit court is provided by law. Now turn to what is page 3, the definitions section, hazardous animal, an animal regardless of breed that, when unprovoked, A, chases or approaches a person without menacing or without an apparent attitude of attack upon the street, sidewalks, any public grounds, or otherwise off the owner's property in such a way so as to place a person in reasonable fear or apprehension of physical injury, or B, obstructs, impedes, hinders, or interferes with a person's right of way on any public street, sidewalk, or on public grounds. Skip down to dangerous animal. There was a typo. A non-word was changed to causal. On page 4, first paragraph, first partial paragraph, it now reads livestock is exempt from the definitions of hazardous, dangerous, or potentially dangerous. Within the definition of serious injury, another non-word was changed to fractured. This ordinance has a new section 2.7-22, hazardous animals restricted. A law enforcement officer shall have the authority to declare and restrict a hazardous animal if the law enforcement officer has probable cause to believe that the animal is hazardous. The declaration must be based upon the written complaint of a citizen who is willing to testify that the animal has acted in a manner which causes it to fall within the definition of hazardous. 2, actions of the animal witnessed by any law enforcement officer or health official, or 3, other substantial evidence. B, a hazardous animal shall be, from and after their declaration as such by a law enforcement officer, restricted to its owner's property. The owner shall be responsible for determining how to restrict the animal, so long as the restriction is humane and provides for adequate exercise and protection from the elements for the animal. The hazardous animal must not be tied or tethered to an inanimate object such as a tree, post, mailbox, or vending machine. C, hazardous animals must also be microchipped at the owner's expense at the time the animal has been determined to be hazardous. D, failure to comply with provisions of this subsection shall result in the animal being deemed potentially dangerous as provided for in this code, with the applicable restrictions and requirement then being enforced against said animal. E, an animal owner shall have 14 calendar days from receipt of a written declaration from a law enforcement officer finding the owner's animal to be hazardous to file a written appeal to the county court. The rest of the changes all deal with bumping section numbers, and that's it.
Okay, J.P. Madison.
I wanted to ask if J.P. Ussery would like to be listed as the sponsor, since he was involved in the crafting of 5.2.
Yes, ma'am, that'd be
Okay,
fine.
well, I think we would all be listed as co.
Yes, ma'am.
Okay. Is
Yes,
that, do we
thank
need,
you.
okay.
Okay, do we need to make a motion to that effect, or can we just?
He just
Okay, here.
says he wants it, and that's it.
Okay.
Thank you.
So we have now read that, so.
It's an
Anyway,
emergency ordinance, and now it needs to be,
Any discussion?
that doesn't need to go to second reading as an emergency ordinance. It needs to be,
Yes.
I move to pass 5.2.
I have a motion and a second to pass 5.2.
now, Judge, may I, before we begin discussion?
Yes.
With the emergency clause, this does require 10 votes to pass tonight. It's 2/3 of the entire court.
So, now, and this, when this passes tonight, will become effective immediately.
Yes.
So, are we ready for the vote? J.P. Harbison?
I still think that we just need one paragraph that animal owners are responsible for the behavior of their animals, period. Thank you.
Thank you, J.P. Harbison. Okay. Any more public discussion? Call the roll, Carly.
Tom Lundstrom. Eva Madison.
Yes.
Sue Madison.
Yes.
Joe Maxwell. Gary McHenry.
No.
Joe Patterson. Butch Pond.
No.
Bill Ussery.
Yes.
Daniel Balls.
Yes.
Harvey Bowman. Rick Cochran.
No.
Robert Dennis.
Yes.
Lisa Ecke? Yes. Ann Harbison? No. Sharon Lloyd?
No.
This ordinance has failed. So we're back to base one.
Yes.
Okay. Do we have any citizens' comments? Do I have a motion to adjourn?
No.
Oh, I'm sorry.
Thank you, Judge. I just got a text message from Robin Lundstrom, Big Tom's daughter-in-law. Big Tom, we call him Big Tom, I'm sorry. J.P. Lundstrom, and she said that his surgery went well yesterday and that he's in very good spirits tonight.
Very good.
And she wanted me to report it to
Very good, thank you.
to the court.
Yes, ma'am.
I just had one quick thing. I called my insurance company, and I know none of it's passed, but anyway, I called my insurance company on the part where it talks about the liability insurance, 50,000. Anyway, according to them, they will not issue, just like if I went out and said, okay, I need liability insurance for my dog in case it bites somebody. They do not issue that type of insurance. And she said she didn't know anybody that did, and a lot of it is covered under your homeowner.
It is.
But if your dog is deemed dangerous, it will not cover it, period. I mean, they will not pick you up. In fact, they'd probably drop you. So I didn't know if that was something you needed to think about, I don't know. She said she just didn't know of anybody that would cover it.
I appreciate you bringing that to the court's attention. Thank you very much. Did I get a motion to adjourn?
Make a motion to adjourn.
All in favor, say aye.
Aye.
Opposed, same sign.